Good evening, everybody. Tom here at 7:04. Sorry we were a couple minutes late. I'm joined by my esteemed colleague, Brian Drew, this evening. Mr. Drew, as you can see, is much better dressed than I. I come to you with my Drifter, Illinois shirt on, and he is in a nice suit, tie in his law office. So hats off to you, counsel.
Well,
go ahead and introduce yourself, my friend.
Hi, I'm Brian Drew. I'm an attorney down in Benton, Illinois, Franklin County. And Tom and I met working on the mass cases and the Emergency Management Act. And we got together again on these assault weapon cases. So I'm very happy that Tom brought me on board and I get to help out. So happy to do it.
Brian's being very modest. He's a very intelligent lawyer and he thinks things through really well. And in our profession, that's an invaluable trait. It's always easy for us to go in off the cuff and make arguments, and we all do it sometimes. But when you're dealing with cases of this magnitude, with this much exposure, Brian is very in tune with, you have to really and methodically plan these things out 10 steps down the road, because if you don't, I assure you that that's what the government's doing, because they're very talented. Brian and I know that. And so you can't willy-nilly take these cases. And so Brian, I'm glad that he was able to have time to help us out, you guys. He's really very good at this stuff. So I needed to talk to you guys about a couple of things that's going on. I haven't given you an update in a week or two for reasons. Brian and I may go back and forth with each other on some of this, kind of interactive, which is fine. He'll chime in anytime that he finds necessary, and I encourage that. So, but as you guys are aware, we have 3 cases. We have the Effingham County case that was filed first, then the White County case, of which Mr. Drew argued very effectively for us over in White County, got a TRO there, and then we got a third TRO in Effingham County. They kind of all have, at least temporarily, all of the clients in those cases are not encumbered by the restraining order. And then in our cases, we procedurally made some very necessary decisions, and we'll get to those in a second. In the meantime, while that was happening, there was another case filed in Macon County that you're all aware of, that was filed by Representative Dan Calkins, as well as a couple of other individuals, and then this association that I don't even need to talk about. And that case is, for all intents and purposes, identical to the one that we filed. There's one difference as it relates to a claim regarding special legislation, but substantively speaking, it's identical to an equal protection argument. So the case is right down to the footnotes, I would even say, actually, it's the case that we had filed in all 3 of our cases. I don't have a problem with that there was a decision made to join into these efforts and use what was really our work. That's fine with me. But there have been things done and decisions made now that are really going to cause, in my opinion, and I think in Mr. Drew's opinion, problems for us to accomplish what we're trying to accomplish. And to the extent that's going to happen, I want you guys to know that it's coming. And if it happens, you're going to understand exactly why.
Hey, Tom, before you get started, we have a record number, nearly 1,100 participants in this live stream. So thank you guys all for participating. And I just dropped Brian's information in the chat as well for the Drew Law Group, so you guys can all access that. So as you two dialogue back and forth, I'll probably look at some of the comments, because let me tell you both, they're absolutely going like crazy. So as important questions come up, I'll probably hit you both with them. But we have over 1,100 people between all our platforms. So thank you both for hosting this forum, because it's absolutely amazing that we have this many people on this live stream.
Thank you. So getting back, now let's go to what are we trying to accomplish, you guys, because we all know we're talking about a gun bill, but there's bigger issues at play here long-term for the state of Illinois than just this bill. And it has to do with the way legislation is crafted and passed in the state of Illinois. Now, we as Republicans or conservatives or as moderates, whatever you want to category you want, we all have an interest in making sure that the government works the way that it's supposed to work, and that it doesn't short circuit and go around the constitutional procedures of how laws are passed, because what that does is it takes the people out of the process. Now, the supermajority of Democrats in Illinois can pass whatever they want to pass. We can't stop them, but we can certainly insist that they follow the procedures that they're supposed to follow and not just thumb their nose at them. That issue in and of itself, long term for the state of Illinois, is as important as this gun bill. And so we are trying to make a real effort at putting an end to that. And the appellate court in our case, number one, already said that the Supreme Court of Illinois should take a look at that issue. They almost encouraged them, as well as the White County judge, saying you need to look at this 3 readings rule procedural issue. If we don't do things exactly how they need to be done, which we're doing in our 3 cases, we may lose the opportunity to ever have a chance in our lifetime to bring that issue as efficiently and as effectively into the Supreme Court than right now. And what's going on in this other case that we're going to talk to you about is going to hurt our chances of ever being able to make that issue effective. And I think that's a huge problem. And we're going to talk about it because I want you guys to know. The other issue that we're trying to do on top of that procedural issue is to deal with this gun bill. Dealing with this gun bill and getting it under state law eliminated. The 3 readings rule, again, is one way to get rid of it, but set that aside for a second. We have the issue of equal protection, that the appellate court has already said there's a likely chance that this law violates equal protection. They have not said it does violate equal protection because that's a final ruling that has to come from one of the lower courts. So the appellate court decision, again, is not an absolute certainty under final judgment principles. It's merely a likelihood. Does this law violate equal protection of the state of Illinois is the question. Now, I have to be a little bit technical with you guys, even though I try to talk in English, and Brian does a good job of speaking in English too, is when this issue gets to the appellate court or to the Supreme Court of Illinois, because it will not go back to the appellate court. If a judge in a lower court rules it unconstitutional, it goes directly to the Supreme Court of Illinois in a direct appeal. And so when the Supreme Court of Illinois looks at this issue, they have to decide what level of scrutiny to apply, which means in English is how close do we look at this? How critical do we get of this exempt categories? Okay, it's the best I can explain it. Maybe when Brian speaks, he'll do a better job. But how critically do they look at it? And if they look at it really critically, at a very high level, government's got a problem. But if they don't look at it at a high level of criticism and they look at it at a lower level, which is called rational basis, the Macon County case is going to have a problem. And we would have a problem if we didn't do what we're doing. So in our efforts to prepare, we are preparing our case to say we don't know which level of criticism the Supreme Court's going to apply to equal protection. And we have to hope for the best, but prepare for the worst. We have to prepare for the possibility that the Supreme Court of Illinois applies a very low analysis to this. And if they apply a low analysis to it, the only way that we can win is by doing discovery requests that I'll get to in a second, and for us to really build our case and to establish with certainty that what they're arguing doesn't make any sense. Okay? So as this case has been proceeding for the last few weeks and a couple of weeks, and you haven't heard from me, but you heard me being critical of this Macon County case, here's what's been going on. We, on your behalf of all of our clients in these 3 cases, Brian and I sent out numerous discovery requests. We sent them to the governor. We sent them to the Speaker of the House. We sent them to the President of the Senate. We sent them to every House and Senate member that involved in this bill. We sent them to the Illinois Department of Corrections. We sent them to the Illinois Police Training Board for training people for weapons. We sent out all kinds of discovery because our purpose of that is to gather up that this has nothing to do with training, that the information does not support that it has anything to do with training. The reason we're doing that is because we absolutely have to have it if the Supreme Court decides that they're not going to apply a high level of criticism or scrutiny to this case. Without that information, and if the Supreme Court makes a decision that they're not going to give a high level of scrutiny, we can't win hardly. And so when we sent all this discovery out, here came the state defendants going, well, Tom, Brian, we don't want to do discovery. We don't want to answer this complaint. Let's just file a quick, what's called a quick shot. I'm going to use quick shot summary judgment. Let's just go to the Supreme Court right now. And I'm like, are you kidding me? That's a horrible idea for my clients. And the states want that because they don't want there to be any information in this case or in these cases that they're training, defense is based on nothing. And I'll get to some details in a second. So what did the state defendants do? They go to Mr. Calkins and say, hey, why don't you want to be the first one to the Supreme Court? Let's take your case to the Supreme Court and we'll go make these arguments about this issue. And he bid on it. And so in me trying to defend you guys, we decided that we were going to ask the Supreme Court to consolidate these cases, all 4 of them, including the Macon County case, so we can kind of tamper down this very bad idea to go run into the Supreme Court of Illinois before we're ready. Does that make sense, you guys? Okay. And so in the meantime, after we filed that, then some more procedural things go on in the Macon County. I'm going to call it the Calkins case, where they're trying to set up even faster. They agreed in 3 days to file final motions in the case. 3 days to file these final motions on issues as important as this. And they're trying to do that in order to argue to the Supreme Court, you shouldn't consolidate in Dan Calkins' case with the other 3 cases because it's so much procedurally different that you should just leave it separate. They want to leave it separate because they know if it gets consolidated with ours, that we're going to insist that they finish the discovery process because we know we need that to have an absolute high likelihood of winning. Okay? That's what's going on procedurally. Let me give you a factual example of what's important. We have been doing, actually, this was done initially by the Edgar County Watchdogs, by Kirk Allen and John Kraft, who we talk, right? They're actually in these cases. And they gathered some information because one of the groups that's exempt out of this law is prison wardens. Okay? Prison wardens. We have 47. And I'm going to give you some facts that Brian and I will use, and Calkins should have been asking for to push back against its adequate training that makes them exempt. There's 47 prisons in the state of Illinois. They're telling us that there's only 27 wardens for the 46 or 7 prisons. Let's assume hypothetically that might be true, that every prison doesn't have a warden. That's 27 men or women that are wardens of the prisons. How many of those 27 people do you think actually have taken any training whatsoever regarding firearms? Guess what? 13 of the 27, if we accept 27. 13. How many of those 13 that have taken training do you think have had any training whatsoever on assault weapons? 0. Those are the facts that Brian and I are gathering on all of these exempt classes, because when we get to the Supreme Court, we want to just be able to push back and say it's got nothing to do with training. It's all ridiculous. Because of facts like that we are gathering that Dan Calkins is going to have 0 of. And so if they rush to the Supreme Court too quick, which is what they're trying to do, and the government says it's all about training, it's all about training, what are they going to have to defend against that? You know what they got? Nothing. They got nothing. And all of the work that I've been doing and all the work that Brian has been doing to fight to get rid of this law and hopefully get rid of this 3 readings rule that they're using to crush the people of this state is going to be at risk because of a politician that wants to be aggrandized and look like a hero running to the Supreme Court before he's ready, before it's ready. Because that's what's going on. There's no other, unless Brian has a different analysis, I'd like to hear it. But that's why this is a problem for all of us. And I want you guys to know, do we still have a fight? Absolutely. But Calkins could take his case to the Supreme Court with nothing, there's probably still, I'm going to hedge here, maybe a 4 out of 5 chance, in my professional opinion. Brian will have his own. They could still maybe win. But if we do what we're talking about doing and taking, it's only about 90 or 120 days more to absolutely nail it down. We go up to 80 or 90% likelihood of not only getting rid of the gun law, but getting rid of the 3 readings violations that they've been doing forever. And it makes no sense to me. Why would we get in this big hurry to run to the Supreme Court? The fact that and again, I'm not disrespecting the governor here or any of the defendants, because they're doing what they think's best for them. I get that. Why would anybody run to the Supreme Court so fast? Because that's what the governor and the state and the president of the Senate and the speaker, that's what they want. The fact that they want that means you should probably say that's not good for us, because they want it, because it procedurally gives them the best shot that they can have. There's nothing for us as plaintiffs to gain by getting in such a big hurry. And again, you guys need to understand this, because I've always been one, you got to know what's going on in these cases so you understand it. There's nothing good come from running to the Supreme Court. If it would have been the best thing to do, guess what? We would have been the ones doing it. You can see Mr. Drew shaking his head. We would have done it. The fact that we're not doing it and the fact that the governor wants it should tell you everything you need to know. And so it's just so disheartening. It's so disheartening. And so, Brian, you go ahead and chime in right now and add anything you want to add. But I wanted people to hear your point of view too, because again, we still have a chance to get everything accomplished we want to accomplish. And that's important to know too. But this is unnecessarily causing some grief. It could be a catastrophic for our issues.
And I think that's exactly right, Tom. The key here is we filed first in Effingham. Case was first. You got the TRO first. We've been to the appellate court. We've won there. And now this case in Macon County that came later is now in a race for no apparent reason to try to beat you to the Supreme Court. And I don't understand why. It makes no sense. There's no need to rush. We're talking about, you're exactly right, 60 to 90 days additional before we get to the Supreme Court, and we'll have all the evidence. And they're going with none. I mean, on several of these issues, the 3 readings rule, we believe, and based on our initial review of the facts, that this ignoring of the 3 readings rule in the Illinois Constitution goes on a regular basis. They've done these midnight votes. They've done this regularly, but none of that's going to be in the Macon County case. Can't be, because they've done no discovery. They haven't done any background. They haven't done anything. It's simply not going to be there. And then on the equal protection, we've done our homework there as well. And we have, and the gentlemen have also helped us out with some FOIA requests, and we've got discovery out there. And a lot of these people aren't trained at all. But the problem is, on the Macon County case, when they go up, if the Supreme Court, which based on the most recent federal decision that came out of the Northern District of Illinois, it is a decent shot that the Illinois Supreme Court is going to not use strict scrutiny. They're going to use one of these lower levels, which could include a rational basis, which might be, they call it heightened scrutiny, but not strict. But either one of those cases, at that point, the state's going to say, look, we exempted these people out because they're highly trained. And and which isn't true, but in the Macon County case,
they can't prove it.
There'll be no evidence at all, no facts at all in their case to refute that. So
and who has the burden, counselor? Who has the burden of proving that, them or us?
We do. Whoever says all the laws are set up that the court's job is to try to figure out how to make this statute constitutional, unless we can prove that it's not. And so they're going up without this. And the problem is when they do that, I'm not saying they can't win. It is possible they could win, but why would you rush there when there's no reason to rush? Why would you rush there and not take all the weapons you could have with you to go into this fight? They're choosing not to do it just so they, in this race they've created to try to beat you to the Supreme Court, to beat us to the Supreme Court, and they're running to do it. And I don't get what the rush is. Look, we all want this bill to go down. But you and I, in this case, I think have a real opportunity to change the way fundamentally the state of Illinois and the legislature acts. They have run these bills through in the midnight hours. They do them with not letting our elected representatives, our elected senators, getting an opportunity to weigh in on it, go to committee, get the evidence out, fill that record full of, no, this isn't the case. This isn't the case. I have questions about this. There's better ways to do this. And instead of doing that, we may not get that opportunity. And that's a big deal, because that's going to affect us for decades to come. If we can get this overturned and undone, the legislature is now going to have to abide by the rules. And what's worse is, and to Tom's credit, we've contacted the Macon County, and Tom said, look, we don't need to be the front runners. If you want to have your name on it,
make sure you explain that, please.
Yeah. I mean, if this is about whose name's on it, we don't know what the reasoning why they're racing to get there. But we said, look, if that's the case, you can argue the motions for summary judgment. Let us get these cases consolidated. We filed the motion to consolidate them all together. Give us 60 days to get this discovery out, to get the rest of this evidence, to get us in our best position to win. And let us do that. And then we'll give the information to you, and you can go argue it. And you can go be the one arguing it the whole way up. We'll be there to support you. We'll argue it too. But you can be the main part. We don't care. It's not about personal vanity. It's not about your own ego in any way. This case is about the state of Illinois, how the legislature does their business, and making them abide by the rules. And then on top of that, getting back our constitutional rights as well with the gun bill. This is bigger than any one individual. This is larger than just these cases. This could have really profound effect on the entire way this state's run. And we have a golden opportunity that we may never get again. And to not go into it with our best chance to win, I don't understand why we would do that. And it's, I don't get it. We're going to keep fighting. We're going to keep moving ahead. We're going to push forward with our discovery. Tom and I are discussing setting up depositions to try to even expedite this even more. But this process takes a little time, but not a lot. But we're going to do everything we can to get that done.
Something worth talking about too, Brian, is because again, folks, on the 14th of February, we filed the request with the Supreme Court of Illinois to consolidate all 4 cases, 3 cases that we have, and the case out of Macon County. Pull them all together because they're all the same case. Again, the case that they filed is, for all intents and purposes, the same cases that we filed, right down to every syllable, pretty close. And so it's not like it's a new argument. There's nothing new.
No.
And so, but that case in Macon County has Dan Calkins listed. It has Perry, I forget Perry's last name, I apologize, the Decatur Jewelry Store, and then this association with 600 or 800 or 1,000 people that may or may not belong to an association. Think about this. So today was the day that the Macon County case had to file a response to the Supreme Court about consolidation. And in that response, it says, and Ryan will put it out there for you all to see, because it's a part of your cases too, that Dan Calkins says that you shouldn't consolidate these cases. Dan Calkins says that discovery is not necessary. Dan Calkins this, Dan Calkins that. What about all the other plaintiffs in those cases? What about all of those good people in this association that paid hard-earned money to have their interests heard? Why aren't their opinions? Maybe they thought discovery was a good idea. Why does Dan Calkins alone get to call the ball on those issues? If I'm one of those members of the association, I'd be pissed. Nobody asked you your opinion. Did Dan Calkins, is the fake creator of the association, did he ask all of you as members what you thought about any of this? Bet he didn't. He made all of those decisions on his own, and that's what the record shows. So whatever happens, he is on the hook for all of it himself. He's on the hook. And you know what? People that have said over the last few weeks, Tom, why are you talking about Dan? Why are you talking? I don't care about Dan. I care about the people of this state. I care about winning this case for the 4,713 citizens and the 148 FFLs. I care about them winning. And in the long run, that's going to benefit the rest of the gun owners of Illinois too. That's what I care about winning. And anything that gets that done, I'm all about it. As Brian told you, I even offered up to let them be the ones that argue it all. You can give Dan Calkins the glory. I don't care. But don't mess it up. And Brian had a good analogy. I won't use it because people say we're talking about guns. But you're going to go to the Supreme Court without all of the best arguments that you need. Why would you do that? There's no reason. Again, Brian and I are pretty smart guys. And we tried going, this doesn't make any sense. I talked to 20 lawyer friends personally that I know going, what am I missing? They're like, dude, you're not missing anything. We're like, that doesn't make any, why would anybody do that? I'm like, I don't know. And again, I don't like to assume that people are motivated by vanity or glory or whatever you want to call it, but I can't come up with anything else. And again, if we lose these cases, if we lose them because Calkins runs to the Supreme Court and loses and I can't help fix it, it's on him. It's on him. Could we still potentially do everything perfectly that Brian and I can do to put the best case up and potentially not win? It's possible in the state court. That's not the federal issue, separate. But again, I'm telling you, and you guys can believe me if you want, we can double the chances of winning by engaging and finishing the discovery processes that Brian and I have put in place. Double our chances because we can push back on, it's all about training. How is it all about training if 0 of your prison wardens have any training, but they can own all these weapons? Can't. But when Calkins runs to the Supreme Court now, he doesn't have any of those facts that I just gave you. You with me? You can't introduce those facts to Supreme Court if you haven't gathered them during your case. You have to get them through your case, which is what we're doing. So when we're ready to go and they say it's about training, I'm going to go, Brian and I'll be going, I don't think so, Scooter. It got nothing to do with training because your wardens ain't none of them trained. And that's a good argument that will defeat their argument. And you know what? They know it will defeat their argument, which is why they're trying to get to the Supreme Court without any of that being in the record. So if Calkins goes there and loses because you ran too fast, remember the Naperville case that we just had in the federal court up in the Northern District, that federal case that they lost their TRO in Naperville? But we're waiting in Southern Illinois for some very good lawyers down here in Southern Illinois. You haven't seen Brian and I get in their way yet, right? Because we know what they're working on and they're smart. The guys in Naperville got in a big hurry. Phew, man, off they went. Didn't work out for them. Getting in a hurry in these cases, guys, is never a good idea because the courts are always, again, the courts by law have to uphold a law as constitutional if the facts will support it in some fashion. And if they're going to find it's unconstitutional, you really got to make your record. You got to have it solid. That's what we're doing. It's not what they're doing. And so again, if they run to the Supreme Court and successful, well, they were successful based upon the arguments that Brian and I have already put together, and they just piggybacked on and took off running with them. None of those arguments that they're going to make at the Supreme Court are their own. They're all ours, and it's fine. But if they go win, great. If they lose, which again, 50-50 at best, in my opinion, it may stop us from being able to make the arguments that we want to make, which would be catastrophic. Because then we're sitting here going, they ran too fast and lost it all. And so now, they may not want to see us on this issue. That's a problem, guys. It can still be fixed because Dan Calkins could withdraw his motion for summary judgment. I don't think he's going to do that. I don't think he will. So that's the story. If Brian's got any more to add, he can add it. It's just, I don't know. It's just hundreds and hundreds and thousands of hours to make sure you get this right. And somebody that would just grab a hold of all of that hard work and your people's hard-earned money that we've used to get to this position and just run off with it on such a haphazard, I can't put my head around it, you guys. And you can tell I'm a little frustrated. I don't get that way much, but go ahead, Brian.
No, honestly, you're right. And the key here is, and I hope they prevail. I hope they somehow pull this off without the discovery and win, because I just want to win at the end of the day. But I don't understand why you put yourself in that position to not have all the tools at your disposal, to not have all the evidence you could use to push them to win. And to take this risk, I don't see what the benefit is of racing there. I've racked my brain like you have. We've talked about this. Tom and I have had conversations nightly, daily, throughout the day. Why are they doing this? Have we missed something? Let's go back through it all. Let's look through it. Maybe we missed something. No, I don't understand the reason for the rush.
Well, there's nothing new in that case, Brian. Their case is our case.
Yes.
It's just not been developed to its finality, right?
No.
I mean, their case is they're arguing and using everything that we created, and I'm okay with that. I don't care. And you're right. If they win, great. But when you're going to fight something this significant, why would you say, let's hurry up and rush and go there with what'd you say? Like with no rounds of ammo. I don't remember the analogy you used. It was funny. If you're going there half cocked, you and I understand that if the Supreme Court doesn't do strict scrutiny and they go rational basis or something lower than strict scrutiny, that the only way we win is if we have a record developed to push back.
Yeah.
And if they go strict scrutiny, it doesn't matter. Everybody's happy. But if they don't go strict scrutiny, which there's a real chance they don't, you cannot win this case on behalf of our clients unless you have all the information that we've gathered and started gathering, like the issue of the wardens. How could they ever explain to the Supreme Court that it's about training when none of your prison wardens have any training with these weapons that have been banned? It's impossible for them to deal with that. But you know what? In Dan Calkins' case, that issue never comes up. Never comes up.
No, it is. I'm frustrated as well, and we want to. I've never seen, and in looking at all these cases through all these years, I've never seen the Attorney General's office fight against consolidating several different cases into one, so they only have to argue at once. I'm sure it may have happened somewhere, and I haven't seen every case that's ever existed. But we've
seen everyone that's existed since COVID, and there were none of them, and we were in all of them.
I got to go to Springfield with everybody else and sit in my line and wait, and because they consolidated them all, the Supreme Court did. This is the only time I've seen the AG's office fight against consolidation, and it's the only time.
Why is the Supreme Court fighting our cases against consolidating in Macon County, Counselor?
What's that?
Why are they fighting it? And they don't want the Macon County case consolidated with ours, right?
Oh no, the AG doesn't because Macon County's agreed not to engage in any discovery. That means the Speaker of the House, that means the President of the Senate never have to raise that right hand, go under oath and say, did you read this bill? Did you gut this bill? Did you do this? Did you do that? They're never going to have to do it. You watch. They haven't answered the complaint. They won't file the first affidavit. Neither one of them will enter into this case in any appreciable way in Macon County at all. In our case, they're going to have to answer that verified complaint under oath. They're going to have to put that right hand up under oath. And that is worth something, because I want to hear what they're going to say, because that's going to play a big role in government, and the people need to know. And I don't care what side of the politics you're on. If you're a Democrat, you should be out there going, you know what? I want my politicians to abide by the Constitution. I want my politicians to be honest with us when they do these things, not to do it at 3 o'clock in the morning or slide stuff by. Let us all talk about it. If it's a good law, let us all talk about it. And you know what? We'll figure it out from there. But you and I are doing what we can the right way. We're going to court. We're doing the discovery, and we're doing this the right way. We're fighting it the way you're supposed to. We're taking it to the court system. And that's just the frustrating part of this, is to go forward to race when there's no reason to race. And I don't get it. It's a little frustrating. We should all be working together. I'd love to sit down with those guys up in Macon County, and we all sit in a room and let's flush out every possible way that we can win this case with all the evidence we can possibly get and work together. I don't understand why they want to run off alone without us. I can't fathom why. It makes no sense to me. So,
and the thing
it may not preclude us from going forward, but we're going to keep fighting. But it's going to put a hindrance if they go up there and they don't win. The first motion you and I are going to get is, this is moot. The Supreme Court's ruled on this. These guys are done. And they're going to object to all our discovery. They're going to drag it out far longer than it needs to be while we're fighting all these procedural issues. And it's just really frustrating.
Mm-hmm.
So, sorry.
Nothing to gain. You said it best, Brian. Nothing to gain. I mean, Dan has given the Attorney General and the Governor everything they want. Everything they want procedurally. Isn't that enough to say, and again, I'm not criticizing, I'm repeating this because I want people to understand. I'm not criticizing the Governor, the Attorney General, or any of them. They're being very clever lawyers because they are very good lawyers. And Calkins gave them procedurally everything they want. And shouldn't that in and of itself be going, why am I doing this? Because when they asked me to do the same thing before they asked Dan, it took me about 2 seconds to start laughing, going, no, I don't think so. Because I know what they're trying to do. I know what they're trying to do. So I don't know. Again, you said because they want to be first to the Supreme Court. That's the only reason that it makes any sense. They want to be first. But why would you want to be first? Again, reducing your chances of success significantly, going, I hope we can still win. Why do I don't get it? I mean, again, I guess that's politicians for you. I don't know, but you know, it's all I got. Ryan, you got any questions?
You guys have all kinds of questions. I'm not sure what extent we want to take these, but the biggest question that we have is, and again, you may not be able to answer this, but I'm going to say it because it's probably been typed 200 plus times now. Is this sabotage? And again, you don't have to answer that, but there's a lot of people that have that question, and we can leave it there, leave it at that.
It's not a question for them to ask Brian or I, in my opinion. That's a question to ask somebody else.
Absolutely.
Before you go to the next one, Brian or Ryan, somebody said over there, well, how could you not see this coming? Again, how do we not see coming that a politician would go collect money in his political campaign account to file a lawsuit and then try to run to the Supreme? I mean, again, how you ever, if you're going to see that coming, then the response would be don't do anything, right? I mean, you can't stop that stuff from happening, but you would hope that, because keep in mind, there's federal cases going on right now, more than one, and we are trying to do what's right by all of our clients by not getting in the way of a couple of really good federal cases in the Southern District. If your goal is to win and get rid of these bills, good lawyers understand that you got to let certain people do certain things, and you can get together on some things. Some things you let one group run with and the other. But no, you can't. I can't foresee that some politician's going to come in and want to be a lawyer and muck things up. I can't plan around that. So go ahead, Ryan.
And then I guess the people are failing to understand the procedural process as it relates to your guys' 3 cases versus his, and why he would be allowed to go to the Supreme Court before you. So if you really want to break that down and articulate that better so people understand that, I think that would be helpful.
Okay, so again, we asked, once I knew that this was going to be an issue, I asked the Supreme Court to consolidate all 4 cases, because you have 3 different circuit courts. You have the Effingham County Circuit Court, the White County Circuit Court, which are all our cases. And then you have the Macon County Court, which is where Dan Calkins' case is at. It's in a different circuit court. And so there's no requirement that just because we filed first, that one of the other courts can't move procedurally faster than the others. I mean, cases move at their own speed. Once they're consolidated together by the Supreme Court, then you can get some kind of cohesiveness on how they move together. But once the governor knew that we were going to, in all of our cases, insist that they come to the carpet and answer these questions, they went running to Macon County looking for a way out procedurally to say, let's short circuit everything and just run to the Supreme Court in the Macon County case. The judge is free and the parties are free to do that procedurally, absent them being consolidated. Whether it makes the best sense for the people of Illinois or not is a completely separate question. So again, we can't stop it in our circuit court cases, and we can't insist that we're first to file, we're first to go to the Supreme Court. It doesn't work that way. Our reason to consolidate these cases the way that we've asked the Supreme Court to do was for the purpose of trying to put some sense around that and to kind of help influence the pace of which all of them move together. You got anything else to add, Brian?
No, I mean, that's pretty clear. I mean, that's where it's at. And procedurally, they're giving up all facts. So they're not digging into discovery. They're not getting any facts from anyone. They're just saying, we're going to go on the face of all the pleadings and go forward. And so they're short circuiting by not having a hearing, by not going to a final hearing and saying, we're just agreeing that we'll have no facts and just go up on the law itself. And there's a big danger in that. And the danger is the level of scrutiny that the Supreme Court does. So it's, what we're going to do is we're going to keep fighting. We're going to keep pushing forward. Tom's filed the motion to consolidate things. The Supreme Court will rule on that. Hopefully they'll consolidate it all and put them all together, and that can help short circuit this. Without that happening, Tom and I will get prepared for the fight of pushing our case. It's not going to stop us. We're going to keep pushing, keep going until a judge shuts us down. But that's where we are.
And again, so if the consolidation, we'll know if the consolidation by the Supreme Court is going to happen very soon, because what the governor's office asked in their response to consolidation is, oh, go ahead and consolidate the Effingham County cases and the White County cases. Let's call those our cases, but leave the Macon County case out. You shouldn't consolidate it, because even though it raises the same legal issues, procedurally it's so much farther along because they don't need to do discovery. Okay, so let's just leave it out. That's what they told the Supreme Court. And what they're saying in English is, again, because it benefits the defendants, is we want to hurry up and run this case, fast forward it, which we can't do if you consolidate them. And we want to fast forward it all the way to the Supreme Court without any factual record, because it helps our chances of actually winning. And if we can win in that quick, fast track case, we'll try to get rid of these other cases where they're really going to make a problem for us. That's what they're trying to do. So again, we can't stop it other than ask the Supreme Court to consolidate, which is why we asked them to consolidate, to try to slow down that possibility and to put the brakes on what is extremely reckless decision making by Dan Calkins. Just so we're clear, it's not Dan Calkins' lawyer. It's Dan Calkins making those decisions. That's what the documents say. So it's all on him. It's not on the members of the law-abiding gun owners of Macon County, because it doesn't say they have any problem with discovery requests. It doesn't say anything about Perry or his business. It says Dan Calkins doesn't want the discovery. So somebody asked over on the sideline, can you still buy guns? Guys, you got to stick with me when we're having conversation. If you heard me say anything today that would remotely suggest that you're still not able to go buy weapons, nothing. So don't read into things. If I don't say it, don't assume it. No, it's got nothing to do with right now, today. I'm talking down the road could hurt our chances of getting to where we want to get. But right now, today, nothing changes. Okay. So again, I didn't say that. Nobody said that. Brian didn't say that. So don't assume anything. Go ahead, Brian or Ryan.
I guess there are some people concerned that you're giving up our legal strategy, but I think we're at an impasse.
Everybody knows our legal strategy. I told them when you're right, the governor knows our legal strategy, you guys. There's no secret rooms. Don't watch too much Law and Order. Brian's laughing. There's no, oh my God, let's come up with this great legal strategy. The governor's lawyers are very good. They know exactly what Brian and I are doing. They know why we're trying to do it. They don't like it. And so they're trying to fight back against it. I know what they're trying to do. I know why they're trying to do it. These types of cases will be won or lost based upon who does the best job at putting the best case together. The lawyers always know what's going on, and they know what the other guys are doing because we do it enough. Brian, you disagree with that?
No, there's no Perry Mason moments in the law. Everybody gets to know what you're doing, your facts. Our discovery and the request to admit put them on full notice. They know where we're going. They understand it. And I think that's why they ran up to Macon County and said, let's get this case flying so we don't have to engage in everything that they're trying to do to us down in Effingham and White counties. So
you segued into the next
question. Let me ask, guys, if something happens and Calkins screws it all up, the guns that you've bought during this time where the restraining order in place is fine. Again, have you heard me say anything tonight about the purchases that you've made during this interim process could be a problem? No. If that was remotely an issue, you would have heard me or Brian say it. Please don't create issues that don't need to be created, guys. I'm begging you. This stuff's too complicated the way it is. If you didn't hear me say it, you hear Brian say it, don't assume it, and don't start talking over in the chat and the sideline. Oh, the gun that I bought under the TRO, I'm going to get in trouble. Stop it. Go ahead, Brian.
No, I was going to say, segue into the second part of that question of your legal strategy is explain, because they don't understand the differentiation of a temporary restraining order versus the full case, and explain what that means and what the importance of the discovery is in your guys' process, not just what the causes of action that Dan is taking up, but the further causes of action that you guys can resolve long term if you get these discovery requests accomplished. I don't think people truly appreciate or understand that. If you want to recap that.
Go ahead, Brian.
I'll try that one. Let me try that one. Let me give one shot at it.
Go, brother.
The short version, maybe. Basically, the Illinois Supreme Court said, hey, we'll weigh in on this 3 readings rule if you keep violating it. The Macon County case is going to have one example, and that's this assault weapons ban. In multiple cases prior to this, the Illinois Supreme Court has said, you know what? You guys need to stop doing that. You need to police yourselves. And if you keep doing it, we may weigh back in on it. But they don't want to weigh back in on it. It's a separation of powers issue. They don't want to weigh in on it. And they'd rather leave it to the legislature to continue to do what they're doing. So having one example, or being able to produce through our discovery, possibly 20, 30, 40, 50 examples, how many ever we can find, that's going to put on an onus on the Supreme Court to say, hey, this isn't an isolated incident. Since your last decision 20, 30 years ago, they've done it umpteen dozen times, and it has a cumulative effect. So I believe it makes a better chance for us to win. Now, the Supreme Court could do it on this one issue. They could do it on the one case, and they could prevail. But why not go forward with it in the best case you can? We're also in the discovery going to get out who gets all this training. Tell it just like we've started. The wardens don't have training. What about other people who work in the prison? There's people who aren't there who carry a weapon into the prison system, who work in the prison system and are keepers of prisons under this definition. I don't want to keep these people from having these weapons, but my question is, how are they any different than all these people here making these comments? Because they're employed, just because they're an employee of the state of Illinois, and it is looking like some of them may not actually have to do the training. No one really knows. And that's what our discovery is going to find out. And we already know that the prison guards or the wardens don't, and they haven't. So I like that.
Hey, let me throw something in there, Brian. So guys, on a temporary restraining order, what that means, and again, it means in this case is that the order in place for the named plaintiffs that you're not bound by this law during this interim process, okay? And that would last, in this case, it would end up lasting till the case is over at the end. And when the appellate court in this case ruled that that was appropriate, they said there's a likelihood that you're going to succeed on the equal protection argument. Likelihood means it looks like you will, but it's not the same thing as saying you have actually won. That's a final ruling that the court issues. That's a permanent final decision at the end of the case. Okay? So a likelihood that you can win, which is where we're at now, to yes, you win. From the time we got the restraining order, because we have likelihood of chance, we are now building our case to get to where we want the court to enter a ruling that says you win permanently. Okay? And so we are maximizing that record to create, yes, we win permanently under any set of facts. We win, regardless of whether the appellate or the Supreme Court looks real close or just kind of looks at a lower level, because we don't know what the Supreme Court's going to do. And so we have to build that case that under any set of facts, we win once we get to the Supreme Court. That's why we're doing discovery. That's why we're asking questions, because none of that stuff was available to us when the Supreme or the appellate court said, it looks like you're going to win this issue on equal protection. But they never said we win because they didn't have all of the record in front of them. So we're building that record right now. And again, one of the examples I gave you was how many prison wardens are trained with assault weapons because they are exempt from this law. They can buy all of them they want, buy all the 50 cals they want, buy all the magazines they want. Guess what? They don't have any training on any of those weapons. And only 13 of about 27 of them have any training at all. We're building that record before we ever ask the judge for a final ruling in the lower court, because we need that information. Without that information, we are exposing ourselves to huge risks that we might not win at the Supreme Court because we don't have the record. We can't, it's our burden to prove that the law is unconstitutional. We have the burden. The governor doesn't have the burden to prove that it's constitutional. We have the burden to prove that it's not. And so we need information to help prove that. We can just go in there and say, oh, it's unconstitutional because you have these 7 categories. And those 7 categories, it's not fair. The Supreme Court's going to laugh at you. And the governor's going to argue, oh, but they're all got training. They're all adequately trained. And that's why we carved them out. And they're going to look at Dan Calkins and say, oh, Dan, they said it's about training. What do you say, Dan? He's got nothing. And we're building the case to say, oh, it's about training, you say. Well, guess what? None of the prison wardens got any training on any of these weapons. And we're going to go to the superintendents. Then we're going to go to all the Department of Corrections employees. Then we're going to go to all the security guards. And we're going to lay them all out and go, well, guess what? They don't have any training. Or if they got training, this is the training that they have, etc. And we're going to build that case to show that their training argument is bull crap. And if you don't have that, and the Supreme Court of Illinois looks at you, I'm talking about Brian and I, or Dan Calkins, and says, well, they're trained. Why isn't it okay to exempt them out if they're trained? And Dan can't say, well, they're not trained. Or Dan can't say anything because he's agreed to not do any discovery. And there's no reason for it. So that's the difference between a temporary order where we're at now, you guys, and a permanent final ruling. You got to nail that thing down on that final ruling. You can't just run forward with only your temporary information, which is what they're trying to get them to do. Because the governor knows if he gets the Macon County case to the Supreme Court first, he's got a pretty good shot of winning. And then if he wins, you all may not be buying assault weapons for the rest of your natural lives in Illinois because one man decided to run off to the Supreme Court when it was too early. And there you go.
I just need to clear up one thing here because we're getting beat up a little bit. Why didn't we sit down in our room with Dan and Dan's attorneys to try to hash this out before it happened? I don't know if either of you want to speak to that. And
you think
why
we didn't try?
Well, I know that.
I'll get peeved off, Brian. Go ahead.
And for the record, before Brian goes, you think Tom's fired up? He's been fired up all day trying to fight for all of. No, I know you laugh, Tom, but he has been trying to fight for you guys all day long, and Brian can probably attest to this as well. Equally trying to fight for you guys to work this out before it got to the point that it is. But go ahead.
Whoever asked that question, I told them, and Brian's going to tell you, I'll do all the work. I'll give it all to you. I'll let you make all the legal arguments. And I'll let Dan Calkins be president of the United States of America because of all the great work he did. So don't, tell me I didn't try. I tried everything in my natural power. Go ahead, Brian.
And they want to know why you have water tonight, Tom.
Because I don't need any alcohol. Go ahead, Brian.
He's fired up enough as it is. No, I've seen, look, the emails are there. The discussions have been had, and we've talked to them, said, hey, just come with us. Let's do this together. Give us 60 days. Give us 90 days. We'll give you what we have. Come in with us. Let's do this together. Let's work together. And they say, no, we feel like we want to move. And I've never got an explanation. I've never seen an explanation as to what the benefit is in going without it, other than they're in a race with themselves to try to be the first ones to the Supreme Court. They weren't the first ones with the case, but they want to recklessly try to get there as fast as possible. And I just think these issues are too big and too important to race with them. So, but Tom's tried. I mean, he's done. he can't do any more than we've done, and he's done to try to get them to all come together. So we've exhausted every possibility other than the Supreme Court agreeing with us and consolidating even the Macon County case into us. If they do that, then we can legally, we can actually get in there and do some stuff, whether they agree or not. So we're trying.
I think you guys have covered most of the questions. If either one of you want to kind of recap or kind of give a summary of the evening and close it up, or if you want to go back and forth on any other topics, that'd be great.
It's important, the state case. I know a lot of people have asked, and I've seen the questions of, hey, what about the federal case? This is with the Bruin case, the Supreme Court, U.S. Supreme Court, they're going to weigh in on this. But I think it's so important to get this before the state Supreme Court. And Tom and I have talked about it a lot, and he'll tell you more, legally about it if he thinks he needs to in this circumstance. But to get it in front of the Illinois Supreme Court, can alter the way the legislature does business, can put them in a predicament where, depending on how the rulings come out in federal court and other places, they may not ever be able to fashion a law that could work. We could put them in a position of not being able to do that by winning in the Illinois courts. I think it could be really big and really important. And that's why we're continuing to push that case, because it is important.
Okay. I don't have anything else, I don't think.
Well, Tom, hey, I really appreciate you letting me be a part of this.
Yes, sir.
Honestly, we have to stop in Illinois where the basically the ends justify the means, that it doesn't matter how you get there as long as you got to do it the right way. And that's what you and I are going to continue to push and make these legislators do it. I don't care who they are. We're going to make them do it the right way.
You know, and that's something that I think, and we talked about it some, Brian, but it escapes this conversation, is what we're dealing with right now. The gun bill is just a symptom of a much bigger issue, right? And the gun bill is a big issue, but it's a symptom of the dysfunction and the cancer that has invaded the legislature of Illinois. And we had, I wouldn't say had, but it's not over yet, a real opportunity to fix that for the people of Illinois. And it's being cast aside to recklessly run to the Supreme Court on this gun bill issue. And it's just so frustrating. I mean, I traveled this state for the last year. I know what's going on. I know what ails us. And fixing this issue of how legislation is passed could do so much good for all people of Illinois. And it's not even getting any thought whatsoever from the others. And it's so disappointing, because to me, Brian, I think that's a bigger issue for governor and the attorney general than this individual gun bill. I think they know at some point in time in the federal courts that the Bruin case is going to strike down this law at some point. I think they know that. But the real issue, the real risk to the state of Illinois, its legislature and its governor and attorney general, is the issues that we're raising and trying to bring, you know, the courts involved in on the way that they pass these laws. They're really worried about that. And they're trying to get Calkins and his people to give them an out to never have to deal and address that stuff.
Yep.
You agree?
Yes.
Thank you. That's another, just a yes out of him.
Yeah.
Okay. All right, Ryan, anything else?
No, there's nothing else, nothing of significance. I just want to thank everyone for joining in. We get a lot of questions. How many people did we have? We had well over 1,200 people for the duration of this broadcast. So, you know, thank you guys. You know, I don't know how long it's been, 58 minutes I'm looking at, and we nearly sustained 1,200 people. And I can't even, this will probably be tens of thousands of views for the replays, because I've had no less than about, I don't know, 1,000 emails in the past 4 hours. So after I sent this out. So I appreciate all of you guys. We're doing our best to take care of you all. Tom and Brian are fighting for you both, and we're doing what we can, guys. And let me tell you, Tom has been passionate all day, but that's because he cares. Brian's probably been equally as passionate all day. And
you guys ought to hear me in his phone calls. That's what I would tell you. They're quite colorful, and they're littered with vulgarity, let's just say.
Oh, well. It's not that. I do get passionate about this.
A few cuss words. I probably cuss more than Brian does, because you can look at his nice suit. You know, I got on a Drifter T-shirt, so I'm probably the guy doing the cussing more than Brian is.
We're both very passionate, but it's for a reason. Look, it's not. This can really affect everybody in the state of Illinois. It's really important stuff. You know, I mean, we joke and we do about it because, you know, we deal with it every day, all day long. It's stressful. It's a lot of work. It's thousands of hours. It's a lot of time, but it's worth it because it's the right thing. And sometimes you got to do the right thing. And you know what? We may not prevail. They may take it away from us. They may do it, but I'll promise you this much. That man here on this video has spent the last 2 years doing nothing but fighting in this state. And I'm doing it with him. And I'm happy to do it with him.
Thank you.
And we're going to fight, and we're going to continue to fight. And they're never going to stop us because we're going to be there to try to make them do it right. So,
thanks, bro.
Yeah, I appreciate it.
Talk to you tomorrow, Ryan. Talk to you tomorrow, Brian.
See you. All right, thank you guys. Have a good night.